Buyer beware. So I heard Lexi in the break, she's absolutely, this is a good clause. When I saw this clause, I'm like, yeah, I like that clause. I can see myself using that clause in different circumstances. I don't buy and sell property. Pretty comprehensive. So it would surprise you if I were to tell you that the buskies were successful in this action in the Supreme Court in Queensland. It wouldn't. Even though, so this is a good clause, but it's not good enough. So what, just given what we've been talking about, so given this clause, which is so comprehensive, seems to have thought through all of the potential issues, and we could read it with this in mind, couldn't we? We could read it to say, nothing that the agent or the seller said about the views to the buyer was said with the intention or knowledge that it would be relied on by the buyer. Nothing that they said about the views or has in fact been relied on by the buyer other than it's specifically set out in this document. Before the buyer entered into this contract, it satisfied itself from its own independent inquiries as to the value of the property being purchased and the extent to which the availability or lack of views impacted that property value. The buyers relied upon its own judgment in purchasing the property. The terms of this contract are the entire agreement, blah, blah, blah. To the extent that there were any representations about the views before the buyer signed the contract, the terms of this contract, which doesn't mention the views at all, supersedes it. And without limitation, nothing that was said about the views about the property, nothing that's been said about the property that it will remain fit, suitable or adequate for any of the purposes that the buyer wishes to use the property for, including sitting around looking at uninterrupted views. But ultimately, so this is a really well-drawn clause, but Lexi, you are right. The buskies won at the end of the day. So what's the reason for that? You just like taking devil's advocate position?
Yeah, usually.
Usually. So, and it comes down to the trade practice, sorry, that's my age again, the ACL, section 18 of the ACL. So the statements that were made about the views were misleading and deceptive statements. They were made to induce the entry into the contract. Sorry, you're right there. They were made and they were relied on, but the reliance doesn't actually matter. They were misleading or deceptive. Evidence was taken, and I mentioned this when I gave you the overview of the case, that the seller had actually taken steps to ensure that the agents didn't know about their plans to build in front. Because they didn't know, and if we go backwards and we look at this, so the way, it's a very expensive thing to build a big complex of buildings like this, and you really want to know you've got money in the bank before you start doing it. So on the whole, what they want to do is sell a whole building before they start selling the next building. So while at the time when they've got this building here and it's just on the plan, oops, sorry, going too far ahead. Forgot I have to get my pen out in advance to do this. But if they're working on selling a building here, and suddenly, and that's waterfront at that stage, and there's people who want to be on the top floor, they don't really want to tell them that there's going to be another building next door which has a similar thing, because they're going to want to buy that instead of filling this whole building that they've got at the time. So they've got their sales strategy for doing it. But also it was sort of suited the sellers for the agents not to know and to be selling this exclusive waterfront property when it wasn't going to end up being waterfront property. Again, thinking about it from a risk allocation point of view, it actually made sense. It was appropriate for them to be the ones who were responsible for the statements that were made at the end of the day. So the court effectively found that Section 18, any clause that tries to limit the effect of Section 18 is void. So as well drafted as this is, and one of the good things about it, because it is well drafted clause, is using the severance rules, we can actually just pull out the provisions that are void in this circumstance and let the broader provisions continue. However, given the wide nature of the provision or the representation that was made, that there will be views, it's really hard to work out which of these wouldn't survive. When I was reading it out in that way before, there were really only a couple of the provisions that continued on. So we learn a few lessons from these kind of cases. And this is, I think that's just an easy set of fact scenario to follow. And I think the result is really sort of counterintuitive in one way, which is why I like to use it as an example. But I don't want you to think that it's a case of any particular authority. It's not changing the law in any way. It's just using what we know about how the contract is read and the role of Section 18 in impacting representations that are made prior to a contract being made in contemporary Australian law. So it's not a particularly exciting case. I think it's only been cited once, and in fact, I think probably the better one to look at in relation to this is, where's it gone? Here. So in relation to this point, there's this 2009 case, which is a High Court decision of Campbell and Backoffice investment. Bad teacher. I have forgotten which judge it is who made this statement, but this comes straight from the judgment. Neither the inclusion of an entire agreement clause in an agreement or the inclusion of a provision is expressly denying reliance upon pre-contractual representations will necessarily prevent the provision of misleading information before a contract was made, constituting a contravention of Section 18. Whether the conduct is misleading or deceptive is a question of fact to be decided by reference to all of the relevant circumstances, of which the terms of the contract are one. So, in other words, the court will look at all of the circumstances, and an entire agreement clause will not be a mechanism for avoiding liability in relation to misleading or deceptive conduct. So, lessons in relation to this, where's it gone? This slide, actually, I spoke to this case a number of years ago now to a group of salespeople in relation to software sales. So I've sort of still got this same slide in my pack from the time. But I think it is important to remember that we as lawyers advise in relation to a broad range of kind of activities. And there are certain things that people do which they may not realise have impact on the way that the contracts that a company uses work. So it is important to ensure that salespeople and those who are operationally involved in negotiating contracts understand that everything isn't superseded by the contract. They don't have free will to say or do what they like. And that it does make sense to make sure that management personnel, those who are involved in the negotiation of the contract and those who are involved in selling of a company's goods and services understand what a puff is, understand why it matters that they don't over-exaggerate, and that they understand what, and that they tell the truth in negotiations, even though we don't really have an overriding duty of good faith in contracting under Australian law. We may not have it. I don't think we really know. I also think as lawyers, we need to take that time to ask our clients what really matters to them. Because clearly, yes, the buskies won, but there's a number of years where they're embroiled in this massive dispute and their deposit is still sitting with the developer. Where if the lawyer, when first got the contract and was asked, is this okay, actually took the time to find out what was really important to them and made sure that the special conditions reflected that, or when they did the searches, pointed out that their assumptions about the building or the uninterrupted views were likely to be incorrect, this all could have been avoided. But probably the most important thing here from your point of view is don't necessarily assume when you see a limitation of liability provision that doesn't specifically seek to exclude the legislation, that it's not operating to exclude the legislation anyway. So we need to think about it a little bit more deeply. So we're going to run out of time, so I'm just going to tell you what's true and what's not true here. A pre-contractual statement that's not reflected in the terms of a contract can nonetheless be misleading or deceptive, which affects the validity of the contract itself. Also, a term of a consumer contract that purports to exclude, restrict or modify any of the rights conferred by or the liabilities imposed by the consumer guarantees or has that effect is also void. Exclusion clauses don't continue to have an important role in consumer contracts. So in consumer contracts in particular, where the ACL in its entirety applies, exclusion clauses have a very, very limited value indeed. And lawyers are going to have to find better tricks to make sure that their clients are actually protected and that the risks are appropriately allocated. But in consumer contracts, even exception clauses that have been properly notified have become terms of the contract and on their true construction are enforceable, may nonetheless still be void and unenforceable. And I don't think we even need the term consumer in there because of the broad reach of Section 18. So we do need to just think about that. What happened before? What representations were made to induce? Were they misleading or deceptive? And that is why that provision is one of the most litigated provisions, or I think it is the most litigated provision in legislation anywhere. So because when you're having a dispute, you throw that in. The conduct leading up to the contract was misleading or deceptive. We'll work from there. So I've spoken about that one. So the next thing I want to spend a little bit of time talking about is the unfair contracts regime. So this is part 2.3 of the ACL, and the ACL itself is Schedule 2 to the Australian Competition and Consumer Law, or Consumer Act, sorry. The part itself is designed to protect consumers from unfair terms in contracts that are offered on a take it or leave it basis. Since November 2016, that's been extended to not just consumers, but to small business as well. And yeah, I think I've got some definitions towards the end in relation to that. The ACL applies only to standard form business to consumer or business to small business contracts. So there is no overarching law that says contracts need to be fair. There is a set of provisions in the Act that say certain kind of contracts, if they are unfair, there are certain consequences to that, including the unfair provisions being void or voidable. So what are unfair contract terms? Section 23 states that a standard form consumer contract cannot contain terms that cause a significant imbalance in consumers' rights, are not reasonably necessary to protect business interests, and cause detriment. So it's a cumulative definition. In order for a term to be unfair, we need it to meet that three-pronged test. Significant imbalance, not reasonably necessary, and cause detriment. So a clause that, or a provision in a standard form contract that does cause a significant imbalance and causes detriment to a consumer might still be a not unfair term, because it is reasonably necessary to protect business interests. Standard form contract, there is no particular definition of what a standard form contract is, but from the memorandum and from the legislation itself and the examples that are given, it's a take it or leave it contract. So the onus is on the party seeking to demonstrate that the contract isn't a standard form contract to prove that it's not a standard form contract. And that kind of makes sense when you think about it, because if you're a telephony company and you sell mobile phones on individual terms with everybody, or you have the same terms with almost everybody, you're the one who's in the best position to bring evidence that your contracts are different with everybody, they're all bespoke, they're not the same. So as a consumer, you can just allege it's a standard form contract, and then the onus is on the other side to demonstrate that it's not. So take it or leave it is really terms where there is very little, if any, ability to negotiate the terms. It might have a form where you put details in the back, but at the end of the day, the invitation to treat is in the form of a contract. You make an offer by making an offer, signing that contract on those terms. You do not have the opportunity to make an offer on different terms, if we're using technical contract language to understand it. There are some terms, before we get into the detail of it, there's some types of terms that will never be subject to the regime. So Section 26 sets these out. They're terms that will define the main subject matter of a consumer contract, set the upfront price, or are required or expressly permitted by law. So just in a nutshell, the reason for these, as I understand it, is it's not for the legislation to say what you can and you cannot contract about. There's other legislation that will say certain types of subject matter is illegal subject matter, and you'll talk about in advance contract illegal subject matter or contracts that are void for illegality. So, for example, you cannot make contracts in relation to slavery. Or you cannot make a contract to murder somebody. This is illegal subject matter. But outside of that, as a general principle of common law, private law, commercial people, you can make contracts about whatever it is that you want to make. And so it can't be unfair to have a contract about lawn mowing or shoes or whatever it is. It's just that's not the subject matter of the contract, is not a matter of fairness or otherwise. In relation to upfront price, and this is upfront price, it's not total consideration but upfront price. I think that comes from this idea that consideration needs to be sufficient, it doesn't need to be adequate. The overall price, particularly hidden fees and charges, or charges or additional charges that operate as a consequence of the way the contract will work, that can fit into the unfair regime. But the actual upfront price, the price you pay on the day that you enter into the contract, can't fall within the unfair regime. And then we've also got this sort of third category, so terms that are required or expressly permitted as a matter of law. And this is just for legislative efficacy, so that we don't end up in the situation where we've got two bits of legislation that compete with each other. That if the law says that you have to have a provision in your contract, for example, the law that this comes from, the Australian Consumer Law, also says, I can't remember the section off the top of my head, if you sell things by knocking on people's doors and offering things for sale, you need to provide them with a written contract, and that written contract needs to have a 7-day cooling off period. Now, the 7 days might not be enough. It might actually be much fairer to allow for a 21-day period or a 12-month period or something similar to that. But the law basically says, Section 26 says, we're not going to deal with that as fairness or otherwise. It's just legislatively more efficient to not have a battle between the different provisions. It's also worth noting that Section 28 provides that associations or companies' constitutions aren't subject to this regime. So again, technically the constitution of a company is a contract between the company and its members, and it can have provisions in it that might fall within the unfair contracts regime, but they're specifically excluded. Similarly, I don't know, I call these the Lindsay Fox objections. Public transport and moving goods around seems to have funny exemptions all the way through the ACL. I do not understand why, but contracts relating to shipping and towage are also excluded, even though they're likely to be standard form arrangements as well. Lastly, the question is only for a court to decide whether a particular term of a standard form contract is unfair or not. You can't the parties don't make that declaration. You need to go to court to get a declaration that a term is or isn't unfair, or is unfair in that case. So as I mentioned before, the regime now also applies to small business since the 12th of November 2016. Anything in particular? So what's important here is you need to look at the legislation to determine what a small business is in order to think about whether the regime may or may not apply in this particular case. So if you've got a contract and you think this term might be unfair, you still have to work out, well, is this in the small business regime, is it in the consumer regime? So it's not a blanket, you're not allowed to include unfair provisions, it's just in relation to those particular areas. If there was an existing contract and the terms of it changed since 12th of November 2016, then the regime will apply to it now. So these provisions have been in since July 2011 in relation to consumers, and that's a long time ago now, so I haven't sort of bothered with that language anymore, but 2016, not so far ago. So in a nutshell, if within the circumstances described by the law a term is unfair, and we'll talk about what those circumstances are in a minute, then the term itself will be void. So if the term can be severed, then the rest of the contract can continue without that clause. And the court needs to determine whether a contract is or is not unfair, and the legislation provides guidance as to the tests that should be used. And a term will be unfair on those three tests that I mentioned before: imbalance of the parties' rights, protection of legitimate interests, and detriments. And we'll talk about that in a second. What's really interesting here is it's quite modern drafting, actually. The law itself provides some examples of what unfair terms look like. And I've got a slide with some headlines on that shortly. But it is quite instructive because it's not saying these are the only things that can be unfair. It's just providing an example. This term meets these criteria in this circumstance. So in consumer and small business contracts, the effect is, or what we need to think about first is, firstly, is it a standard form contract? Okay, is it a take it or leave it contract? The onus of proof is on the party seeking to say it's not. So that's section 27, talk about that in a second. Next, we have to work out, is it a consumer contract or a small business contract? And again, you need to look at the legislation to work out if it applies. Then, it's only then that it's relevant that the term is or isn't unfair. And if all of those line up, then we have a void provision. So, void, treated as if it didn't exist. So if the contract can't exist make any sense without that provision, the whole contract falls over. But if it can be severed, we continue from there. Oh, so let's identify what an unfair term is now. 3 tests: significant imbalance. So the claimant must establish on the balance of probabilities that terms are not transparent. Oh, sorry. I'm reading from the slide. I need to not look at the slide and then I don't get myself confused. So it's for the claimant to demonstrate on the balance of probabilities that the term as provided in the agreement is unfair. It's unfair generally, not just specifically to that party, but that it is an unfair term. A term won't be unfair just because it's lacking in transparency, and terms that are transparent might still be unfair, but the courts will take into account the extent to which there is transparency, so the extent to which it makes sense. So when we talk about things that have been found to be unfair, include things like hidden fees and charges, additional charges that were unexpected, that the parties just would not have understood that they were going to incur without going deep into the contract, and even then they might have to go to a number of different places to do them. Sometimes you can have you can't just fix it by having in bold somewhere in the knowledge that people are unlikely to read the terms. By entering into this contract, you sell your soul to the devil. There's a very interesting, a very funny little YouTube clip by that somebody, Tran, can't remember, she's a famous YouTube blogger on all sorts of different things, but she's, yes, got basically a sell your soul to the devil in the small terms. Sorry, I'm in your way. Worth having a look at. You can't fix your fairness issue just by making the term transparent, making it really clear. If it's unfair, it's unfair. But it's not necessarily unfair when it's not transparent, but the courts will take the lack of transparency into account as they're determining whether it's fair or not. Also, there's no idea of good faith. That was a very untransparent discussion of transparency, I can see. There's no idea of good faith here. There is no presumption that a party has to act in good faith. The question is only whether the individual terms create a significant imbalance in the relationship of the parties. Secondly, the term needs to be not reasonably necessary to protect the legitimate interests of the advantaged party. So it's difficult when you've got those double negatives. A term might appear, so let me give you an example actually. When we looked at the Davis car parking case earlier, initially, particularly when you contrast it with West, you're thinking actually that exclusion term looks unfair, that there's this broad exclusion provision that means that if people's cars get stolen from that parking garage, that they're the ones who have to foot the bill, or their insurers have to foot the bill. But then the court explained, well, actually, if the parking garage was going to take on that responsibility, the cost of parking would go up for everybody because their insurance would be absolutely through the roof. So it is reasonably necessary to protect their legitimate business interest and to protect the ongoing price for consumers. So again, a term which might appear that there's a significant imbalance, I haven't been negligent, you've been negligent, and my car got stolen, and you're seeking to use this term to protect you, that's a significant imbalance in our rights, but it's there because it protects a legitimate business interest. Make sense? So this is a rebuttable presumption again. So you remember we've talked about rebuttable presumptions when we did intention before. So we start from the position that if the term looks unfair, that we have this significant imbalance in place, then it looks unfair, then it's not reasonably necessary. And so the onus goes to the party who's seeking to rebut the presumption to demonstrate that it is reasonably necessary. Again, that makes complete sense, because if you're having a fight with the parking garage about whether or not their exclusion clause is necessary for them or not, they're in the best position to bring evidence very quickly about what their insurance bill would be without that clause and what their insurance bill would be with that clause, and what the corresponding impact would be on the prices that they charge for parking, what their competitors charge, and how they would go out of business. It would be very difficult for you or for a consumer to actually, if that onus was reversed, because you've got no insight into the legitimate business practices. The next part is, would it cause detriment if the clause was relied on? So the question, it's likelihood of detriment is not enough. At the same time, detriment doesn't need to be financial detriment. It can be inconvenience, it can be complexity, it can be any kind of detriment if the clause is relied on. So, for example, you can't port your telephone number to, there used to be terms at some stage where you couldn't port your mobile phone from one provider to another. There was an inconvenience detriment there. There was, for some people, letterhead and business cards and all the rest of it changed, but for consumers, usually it's just an inconvenience detriment. It's not a financial detriment. But, well, there's different legislation that says that they have to do that now, but that's the example that went in my head. So the court may take into account any matters that it thinks it's relevant, and it must at least consider the extent to which the term is transparent. So even though transparency doesn't necessarily, it's not decisive, it's a relevant criteria, and it must consider the term in the context of the contract as a whole. So a term that sits by itself that might look very onerous, if it's sitting in a larger context and there are other mitigating factors, it looks at it as a contract as a whole. So what do we mean here by transparency? I forgot I had a slide, would have made it easier than me tripping over my tongue a minute ago. So a term of a consumer contract will be transparent if all of the following things happen. It needs to be in plain or reasonably plain language. It needs to be legible, so it needs to be of a font size, not shouty caps as we were talking about earlier. It needs to be presented in a clear way, and it needs to be readily available to any party affected by the term. Before these provisions came in, one of the issues that was coming up quite often in relation to consumer mobile telephone contracts and internet provider contracts is the contracts were available online, but it was near impossible to work out which version of the contracts were your version of the contract because it would just change online all the time, and unless you knew the date that you entered into a contract, it was very difficult. So contracts were not readily available to parties who were affected by them. Transparency is merely one factor, though, that the court needs to consider. So this actually comes from a UK case, but I think it actually just enunciates the concept as well as it's going to be. Just because a highly skilled lawyer can find or contrive some equivocation in a word, that does not make the language lacking in plainness or intelligibility. Oops. So, like I said before, Section 25 provides 14 examples of unconscionable terms. It is worth going and having a look at the section. It can be quite instructive. This stuff is usually quite fun too, because you're all entering into consumer contracts all the time, and having that stuff in front of you can make you a much more informed consumer. So I haven't got all of them there, but things like terms which permit a unilateral change by one party to the contract. So think of your mortgage, for example, where there is a term that will say that the bank can change the mortgage rate. And as has been in the papers quite a lot recently, they don't have to do it just because the RBA changes the rate. There's not necessarily a link there. Sometimes they just change it anyway. Now, again, some people will, I have no doubt, particularly following the Royal Commission, push for arguments that those terms may in fact be unfair terms. It'll be very interesting to see if they can get it up. There's transparency issues. There are also issues around, and what the banks will argue, and always do argue, is that it's reasonably necessary for their business efficacy. But interesting. Other places where I've seen this come out, in particular where it's interesting in relation to small business, is in franchise agreements. So a franchise is basically the master franchisor or the franchise owner usually has some brand, some intellectual property, some way of doing business. So think of McDonald's. So McDonald's, there's a master franchisor in Australia, and basically they run some shops of their own, but then they also license the McDonald's branding, their methodologies for doing things, all sorts of stuff to the franchisees. And then every now and then they change things. So for example, they might introduce a whole new menu item. And their contract, the master franchise, will allow them to introduce new terms and conditions, so that you must put this signage out the front, or that you must stop selling this particular product and start selling that particular product. Now you must put a cafe in your premises as well as your fast food restaurant, or whatever those things are. So, and often again, business efficacy is how those have been argued. Often, in fact, McDonald's is probably the worst example, because franchises for McDonald's are so expensive that they are very rarely small businesses anymore. Where the cases have come up have largely been in relation to bread shops, actually, where they've changed. So Brumby's Bread, and there's one called Need, spelt like Need the Bread, No Need Bread franchises or whatever. There's quite a few cases that came out of that franchise arrangement. So particularly when, well, if they're just changing the operation of the shop, that's business efficacy and consistency across all of the arrangements. But when they unilaterally change territories, so if a franchisee has exclusive rights to, I don't know, the northern suburbs, and then 2 years later it becomes to a strip from Laylaw across to Greensborough, and then suddenly it becomes just McLeod and Watsonia, and then it's half of Watsonia, and it's like, so the territory keeps getting smaller. Often franchise agreements will have those kind of provisions where they can change those things unilaterally, change pricing, etc. So, and whether they're unfair or not, we'll see through those tests. Other types of terms that limit the rights of parties, so limit the rights of parties. So things like exclusion clause, disclaimers, the things that we've been talking about today. Terms that penalise a party for a breach or for termination of the contract. So again, the example I spoke about in the first half of the class, which was just on the news coming in today, was discussions about mobile phone bills getting absolutely out of control because people have signed up to a plan not understanding that certain calls might be international calls, or if they run over their data that they can still use the data, they're just being charged at a much higher rate for it. And then if they pay late, or if they don't pay, or if they terminate, then there's early termination fees, those additional charges. So the question becomes, so if you're trying to get out of those contracts, so a phone contract's a really good example. Usually if you leave early, you have to pay the balance of the price for the phone, but if there's a penalty, it might be an unfair term. Terms that prevent you from assigning your benefits under the contract to somebody else, they can sometimes be unfair. Franchising is a good example of that. It's quite standard in a franchise agreement to say the franchisor can sell its business and the master franchise to anybody it wants, and you just have to agree. But you can't sell your business to anybody else as the franchisee without approval. And that often, those kind of terms in small business, so that the parties might be companies, and it will say it'll be a breach of the contract if the ownership of the company changes, or if the directors of the company change. That's also quite usual. So again, sometimes they're there for business efficacy, sometimes they're unfair. We need to apply the test to see what the reasons are. So section 27, that's where we find out what a standard form contract is. I think I've spoken about this enough. My ancient, now fairly ancient legal dictionary uses this language: a contract that's not individually negotiated by the parties but contains the same terms for all transactions of that type, also known as contracts of adhesion. And that's the language that your textbook uses as well, refers to these things, contracts of adhesion. So again, I'm not really sure where that language comes from originally, but usually you've got what you're doing is you're attaching a schedule that has the unique details for the contract. So you'll usually have a set of terms and conditions. It'll have the name of the party that's offering the goods or the services or whatever it is, the name of the large entity, and then you will often just be handwriting in the details of the person who's buying the phone or the electricity or the gas or whatever that standard, or the education, whatever your standard arrangement is. So you often obvious, printed form, you don't have an opportunity, or it's not obvious that you have an opportunity to negotiate. And even you're ticking your box on a website. If you want to buy something online, you've got absolutely no ability to negotiate. You're just ticking a box. Often we don't even see the terms unless we go out of our way to look. So, again, nothing terribly new about this. Just because it's a standard form contract doesn't mean that the rules of construction are varied in any particular way. So, extrinsic evidence isn't admissible or relevant to the construction of a standard form contract, because a standard form contract always means the same thing. So it's going to, if I offer all of you terms and conditions that are the same, it doesn't actually matter what conversation I had with Grace or with Elliot beforehand, because all of those contracts are all going to mean the same thing. So the extrinsic evidence doesn't, if once we've got to that standard form contract stage. Now that doesn't mean that if I participate in misleading or deceptive conduct, that's not a separate issue. But in relation to understanding what the contract means, it's not relevant what conversations I had with individuals. The contract will mean the same thing with everyone. The advertising I gave to the world might be relevant, but nothing really much more than that. Standard form contract must be construed strictly according to its express terms. So what it says in the four corners of the contract is how we read a standard form contract. I think I've covered this point already as I've been going through, that it makes sense that the party who is responsible for arguing that it's not a standard form contract, if they're trying to avoid this requirement, is the party who has offered the contract in the first place, that it's a rebuttable presumption. They are the party that is in the best position to bring that evidence. So, now, the meaty stuff. What does the court need to consider in order to work out whether something is or isn't unfair? And again, section 27 sub 2 sets out the requirements in some detail, and they include things like whether one of the parties has all or most of the bargaining power, which really goes to is it negotiable or not? Whether the contract was prepared by one party before any discussion or negotiation. Whether another party was in effect required either to accept or reject the terms of the contract. So it's a binary position. Whether another party was given an effective opportunity to negotiate, and whether the terms of the contract take into account the specific characteristics, or are they general in nature. And again, the regulations can add something else in. Section 251 of the Act sets out what the regulator can do. So I've tried here in this tiny print table to try and look at what the remedies are, where they come from, but they work differently depending on who's bringing the enforcement action. So that because of the way that the ACL regime works, the ACCC itself can bring an action if it considers a term to be unfair. So even though it doesn't have privity in relation to the contract, it has a statutory right to bring an action. So in relation to the first one, both an individual party to the contract or the regulator can seek an order from the court under Section 250 that a term is unfair. Either of them can seek an injunction to prevent the term being used. So whether that means being relied on by the person who's got it in the contract or in relation to future contracts. Neither of them, though, can seek damages at that first stage. So the reason for this is, and I've put all of the language on there, why have I gone so, I just want to make sure I don't say it in a way that's inconsistent with what I've written down. So Section 15 itself provides that conduct consisting merely avoiding an unfair term doesn't constitute a contravention. So you actually have to act on the term after the term has been made void. So if a declaration is made and then a party seeks to rely on that term after the declaration is made, then damages can be caught. Otherwise, the term itself just has to be severed out of the contract. There's no damages, but the contract will continue without that particular provision. You're looking very stressed at me, or are you just trying to think through the logic of it? So we start with a declaration that the term is unfair. Until the term is unfair, there's no breach of the Act, until that declaration is made. If once the term has been declared unfair, then the question is, can we just sever it out of the contract and continue without it? Great. If we can, there's no problem. Nobody's suffering any damages. It's fine. If you can't, then the contract itself needs to be terminated. But again, that means that the individual, if there is one who's brought that action, they're out of the contract then. They don't have any problem anymore. But if the party who's made the contract, our telephone company, our gas company, our franchisor, whoever it is who's providing these standard form contracts, if they then continue to seek to rely on that contract, particularly with the first party, then damage can accrue. So this is it's kind of interesting here because really the damage that's most likely is the cost involved in getting the declaration in the first place, which is why the consumers are wanting the ACCC to do it and why the ACCC wants the power to do that, because otherwise we're talking about lots of little consumers with all the same problem and the cost that's involved when they've got no damages consequence. So this is also about efficiency. In relation to compensation, compensation only happens when the term's relied on after a declaration of an unfairness is made. Both the ACCC and a person who has suffered damage then as a consequence of the term being relied on after that date can claim damages, but only the ACCC can get an order for non-party damages for redress, which makes sense because parties can get damages for the damage that they suffer, which will make a lot more sense to you when you do advanced contract. And those of you, apparently we've got some OUA students who are doing advanced at the same time as this. So you guys will be all on top of it, absolutely. Questions, concerns, frustrations? That's all I have to tell you, and it's only 8 o'clock. So I might have rushed a little bit more than I thought. I've never misjudged the time early before. I've only ever misjudged it late. So you sure you haven't got any questions?